This is an appeal from the Court of Appeal of Trinidad and Tobago involving the brothers Adesh and Prakash Maharaj and the Ministry for Energy and Energy Affairs. The appeal is being heard remotely, with each of the lawyers and members of the board sitting in different locations in response to the UK government's instructions about our response to the coronavirus pandemic. We have had technical problems which have delayed the start of this hearing, and for which I apologise. I hope that there will be no others, but I ask parties to be patient to allow our IT team to address any problems which we may encounter. I obviously hope that we don't encounter more. The live stream video will, of course, look different to our usual output, but we hope that it will serve as a satisfactory record of the proceedings. We will make the footage from today's hearing available on demand via our website within 48 hours. In order to reduce interference and echoes and to prevent the camera from being attracted to someone other than the person speaking, I have asked the IT members of staff hosting this meeting to keep muted the microphones of everyone other than the person speaking at the time. If you wish to speak while someone else is speaking, please indicate by raising your hand so that the speaker can see and pause to allow you to speak. When he or she does, would the person who is then to speak please pause briefly before speaking to allow the IT staff to unmute your microphone. I turn then to the introductions. I will invite my colleagues to raise her or his, or in this case his, right hand as an introduction when I say their names before inviting counsel to introduce themselves. I am Lord Hodge. I will introduce my colleagues now and will pause to allow their images to be displayed momentarily in the broadcast. Because of our technical problem, Lord Lloyd Jones's image will not be able to be shown, so I will move on to Lord Briggs. Thank you. Lord Sales. Lord Hamlin. Thank you. May I invite Mr. Knox to introduce counsel and then proceed with the appeal?
My Lords, I appear on behalf of the appellants. My learned friend, Mr. Tom Rowe, QC, appears for the respondent. My Lord, I also am assisted by Mr. Ramesh Maharaj, Senior Counsel, and Mr. Rob Strang, although they are not themselves present on this WebEx. But they are listening in, I understand. My Lords, as my Lord Hodge said, this case arises out of the suspension, or as the appellants say, the revocation of their licenses to operate retail petroleum stations in December 2012. And if I can just summarize my 4 main points which I seek to make good. First, the Minister had no power to suspend the appellant's licenses, and the Court of Appeal was wrong to hold that he did. Therefore, if the licenses were merely suspended and not revoked, the Minister, for that reason alone, acted unlawfully. Secondly, the effect of the Minister's actions was in fact to revoke the licenses. And that was unlawful because whether or not there was a term in the license authorizing revocation breach, he did not purport to revoke the licenses at all. Further, he did not, and this is important, seek to justify actions at the trial for the judge, or indeed in the Court of Appeal, as a justified revocation. And most importantly of all, in any event, to revoke the licenses, the Minister would have had to have proved a breach of the terms of the license. It wasn't enough just to leave the thing as a matter of law. He had to prove a breach to revoke a license. Thirdly, I say that the appellants are therefore entitled to damages, first of all, under the Petroleum Act, for the wrongful revocation of their licenses. And their licenses expired, it seems, in the case of Prakash in May 2014, or at least May 2013, and in the case of Adesh in December 2013. So we say, at a minimum, they are entitled to damages for the wrongful revocation of their licenses up to that date. But we also say that they are entitled to damages for the further loss of their ability to renew licenses after the dates I've. Because in practice, the way these licenses worked was once you had a license, it was to be renewed, unless, of course, there was good reason not to. We say there was no evidence here that the minister had good reason, or he didn't establish, rather, he had good reason not to. We also say, as far as damages are concerned, that we are entitled, the appellants are entitled to damages under the Constitution, because the wrongful revocation of their licenses amounted to a deprivation of their property without compensation and without due process of the law. And we say that applies both if there was wrongful revocation and also, unlike in the case of the Act, also if there was a wrongful suspension. Because both, whichever way you look at it, the act of revocation or suspension has caused it. Finally, we say if, and this is, forgive me if I put this in a rather convoluted way, but I think it's the only way I can do it. If there was a power to suspend, and if there was no revocation, then the suspension was carried out unfairly. And on that basis, we say we would be entitled to damages under the Constitution, or at least to a declaration that our licenses were unfairly suspended or taken away from us. My lords, we recognise, although initially our claim, of course, was one for mandamus and for the restoration of our licenses, too much time has now gone by. It's 7.5 years or so for the licenses realistically to be given back to our clients. And we also pray that in aid in our claim for damages. We say it's not our fault, if we're right, not our fault that we are in a position now where we can't get back what we've lost by virtue of the delay in these proceedings. My lords, what I propose to do first is very briefly just take you to the main landmarks in the chronology for each of the two appellants. There's an awful lot of detail. I propose just to go through what you might call the big landmarks, so one has an overview of what happened in each individual case. But I don't propose to take very long. And then I shall just emphasize what the issues before the judge were, which is terribly important in this case to understand what the judge was actually dealing with and the nature of the agreement for her. And then I shall simply run through the arguments which I've indicated. My lords, if I can deal first with the point on the chronology, if I can deal with the appellants individually for a moment rather than dealing with the matter together. If I can start with Prakash, and we have got at page 2057, the agreed chronology, and it may be helpful if I just emphasize one or two points in that which we say are important to bear in mind when considering the issues. I'll deal first, as I said, with Prakash. On the first page of the chronology, 2057, Prakash's parents and he and his brother Adesh buy the freehold of the Fyzabad petrol station. And then over the page, Prakash becomes the National Petroleum, I think, MP authorized dealer. And he has, basically from 2001 onwards, he alone operates the Firespan petrol station. And my lords, we don't have to get into the factual details, but he simply says around this time, paragraphs 2 and 3, he reconfigures the way the system is on. And that's a large part of his defense. He says in the old days, it used to be operated in a way where the storage tanks went back, but he reconfigured it. And from this point on, from 2001, Prakash is the holder of an annual license issued by the ministry under the Act. And that's common. If one can then go to page 2062, at the top of the page, mid-2010, this is when the minister decides that the terms and conditions of the retail marketing licenses are inadequate to regulate the retail of petroleum products, and he directs the ministry to review the licensing instrument. And as a result of that, no further paper licenses are issued. And certainly none were issued up to any material time before the hearing. So from that point on, there are no further paper licenses. On the same page, on the 1st of May 2011, Cash's last paper license comes to an end. But he says, and one can see it from the receipts, he does in fact pay for further licenses, it would seem, for the years 2012 and 2013. I'll come to those in a moment. Moving on to page 2063, halfway down the page, June 2012. My lords, this actually is what appears to have triggered everything. Halfway down June 2012, it looks as if the problem that's arisen in this case is an informant tells the ministry that basically road tanker wagons would offload at Prakash's private premises at Business Compound fuel that wasn't being accepted at King's Wharf, and that Prakash and Adesh were involved in fuel adulteration blending at Business Compound. That seems to have been the trigger, or at least the cause of suspicion on the part of the ministry. And then going over the page to 2064, at the bottom of the page, you'll have the first of the inspections, 28th of November, the first of the inspections of Prakash's station. And that's quite, and there's a lot of conflicting evidence about it. Perhaps the only thing to note is that a couple of samples were taken of the liquid in the tanks at the above storage tanks at the back of the premises. And it was suspected that Prakash was storing condensate, unlawfully storing condensate. And essentially the nature of the allegation against Prakash was that he had all this liquid at the back of the premises, which he was funneling into the underground storage tanks on his premises, which would then be funneled back up to the petrol pumps. And so he was selling dud. That was the essential. On the 28th of November, it's not in the chronology, but he was barred from the premises from that. A security guard was posted. He says, this is at page 14 of bundle. He's excluded from the premises on the 28th. Then over the page, 2065, an allegation which in the end appeared to go nowhere, but the Minister of Energy's officials also go to Prakash's premises at Twister's compound, make an inspection there. And again, there's a dispute about it. On the following day, I'm on page 2065, 29th of November 2012, according to the evidence, although according to the report itself, 26th of December 2012, fire officials went to Prakash's station, and they took a rather more laid-back attitude. They basically said you need to, there are things you need to put right within 90 days. But in fact, from this point on, Prakash is excluded from his. Moving on, page 2066. There's a further visit at the top of the page, paragraph 2, on the 30th of November, when the ministry officials again go to Prakash station and take more samples, at this time taking samples from the petrol pumps. Over the page, 2067, 5th of December, is the date of the receipt acknowledging payment of $2,000 for the renewal of Prakash's license to sell retail marketing for petroleum products for the year 2013. It would look as if, it's not totally clear, but if one goes to page 111 onwards, it would look as if what he was doing was actually paying for a license to start from May 2013 to go to May 2014. But it wasn't clearly set out in the end. But that's what it looks as if is the position from the receipts. But at the very least, this shows that his license continues to May. Going on a few pages, to page 2068. On the 7th of January, Prakash receives his notice of non-compliance pursuant to Section 17 of the Petroleum Act. And that is a notice which, under the Act, I'll come to the Act later, is served essentially if it would seem if the ministry was anticipating revoking. It's a notice you serve before revocation. And the 4, 5, 6 complaints, my lords, you'll have seen them from the papers. Essentially, you're running an unauthorized warehouse and you're cheating, because what you're doing is you've got this liquid at the back, which you're mixing into the underground storage tanks. And you set the whole thing up so you can do that. And there were 1 or 2 other allegations as well. Over the page, 2069, Prakash makes his application for judicial review, and he answers the various complaints which are made in the notice of non-compliance. And my lords, I should just show you the relief which he claims. This is in volume 1. I'll show you what it was after. I think it's volume 1, and you can see at page 8 the relief he's seeking. It includes a declaration, an order of mandamus, for him to be reinstated or to reinstate the license, damages including aggravated damages and so forth. And just a couple of pages on, if I may, page 19, you'll see that what he has complained, the way he puts it, is that what's happened under 6.3 on page 19, he complains that the decision was one to suspend and or revoke the license. Page 19, under 6.3. On the 27th, my lords, going on a few pages, page 2073, this is a date which should have been in the chronology, but it's not. But I can just give you, it's a formal date. On the 27th of June 2013, leave was granted for Prakash and indeed for Adesh. And the reference to that is bundle 5, page 1721, paragraph 19. My lords, there was then quite a lot of investigation by the ministry or its officials, but at the foot of this page, 2073, you'll see 14, 15, 10, 13, the ministry's investigation. And that essentially recommends that the minister bars Prakash from operating his service. Now, throughout this time, what Prakash says is he was not consulted on any of the experiments or tests that were going. But it's important to note, this is the point at which the investigation was made. It's not immediately revealed to him, but if you go over the page, my lord, it should be in the chronology, but it's not. But if I can just give you another date to put in the chronology, on the 25th of November 2013, the permanent secretary to the ministry writes to Prakash saying, we've concluded investigations, and it gives a summary of what it's done and invites the comments. And my lords, perhaps I can just ask you to turn that up, because it's the moment at which the investigation, so to speak, moves from the investigators to the ministry making some sort of formal communication with Cash. And that's at bundle 3, page 1228. So this is the point at which Prakash is invited to make some comments. 1228, bundle 3. And you'll see the minister writes to him saying, we've concluded investigations, and then submitted for your information and comments or any response which you may seek to supply in response to. And my lords, on this same page, 2074, on the same day, Mr. Ramdahin files an affidavit. You'll see 25th November, half of the page. He files an affidavit which exhibits his investigation report. Now, Prakash does not answer the minister direct by a letter saying this is all jolly unfair. What he does do, however, is, and again, this is not in the chronology, and I do apologize, on the 23rd of December 2013, he replies, he puts in evidence in reply to the investigation. And that's at page bundle 3, page 1214. So as things stand at this point, there is a sort of standoff, if I can put it that way. The minister said, this is what the investigation shows. Prakash says, I don't agree with anything you say. That's how things are by the end of 2013. But things change on the 16th. Forgive me.
Lord Briggs, could you give me that last page reference again? That's the Prakash's evidence in reply.
Volume 3, page 1214.
Thank you.
So you have the standoff at the end of 2013, if I could put it that way. The only but important alteration comes on the 16th of May 2014, just a couple of months before the hearing in front of Madam Justice, I think shortly before the hearing before Madam Justice Govind, when the minister makes the point that Prakash doesn't even have a license anyway. He's just got a mere sort of de facto permission. And the reference to that is at volume 5, page 1616 to 1617. And while I'm on that point, he takes the same point, but even in more forceful terms in relation to Adesh at volume 5, page 1644. And my lords, the reason I emphasize that is that whatever one may say about the position up until then, it was quite plain from May 2014 that the minister was not suspending, not just suspending the license. He's basically saying we haven't got one. And then, my lords, as I'm on this page, the judgment of Madam Justice Govind is on the 25th of July 2014. She finds in the claimant's favour, but they are not allowed back into the premises pending the appeal, which eventually goes against my clients on the 3rd of November 2017. So the position, in fact, is my client's been out of the premises since 2000. Those are the main points in relation to Prakash. In relation to Adesh, I think I can take it more briefly. Going back to page 2057, in the late 1960s, his father leases the petrol station at King's Wharf, which he eventually took over with annual licenses. Going to page 2059, the second entrance page under about 2003, before 2007, the service bay at King's Wharf petrol station is converted with the Minister's approval, Adesh said. So that's when he says everything is altered with the Minister's approval, and so forth. He then, over the page, 2060, on the 6th of March 2007, Adesh's father dies while Adesh's license is in force. There's Adesh's father. And then there's communications between Adesh's widow and Adesh and the ministry and NP officials, the effect of which the judge accepted was that Adesh was entitled to take over both the role as licensee from National Petroleum and also as licensee from the minister. There doesn't appear, unlike with Prakash, there doesn't appear to be a formal agreement between National Petroleum and Adesh. Over the page, 2061, I think it's now common ground, the second entry down, and the judge found as much. 2008 to 2012, the ministry acknowledges Adesh as license holder of the King's Wharf petrol station in its annual inspections. And then moving on, 2063, the entry I took you to in relation to Prakash, halfway down the page, the tip-off, which involves Adesh as well as Prakash, during 2012. And then going to page 2066, the 1st of December. So this is shortly after the 2 visits to Prakash's station. On the 1st of December, about 3/4 of the way down the page, you'll see paragraph number 3. In the afternoon, ministry officials go to Adesh's station, and it is closed off from that point on. So he doesn't get back in from the 1st of December. Over the page, 2067, Adesh does, however, pay. This is on the 31st of December. Adesh pays $2,000 for the license, which will continue to 2013. In other words, the 31st December. And the reference is given. Not much happens in Adesh's case until you get to 2070. On the 1st of March 2013, he issues his application without notice, and that's at page 36. Can I just show you how he put his complaint? It's not quite the same way as the way it was put by Prakash. I think it's in volume 1. And if I can take it for the moment, page 52, which is his complaint as amended, because when he made his application, he hadn't been served a notice of non-compliance, but he was served one later. So you can see how he puts it, page 52, after service of the notice. His complaint is at page 53. What he complains about is he doesn't use the phrase revocation, but he complains about the decision to suspend his operations. And then he goes on in para 1A, which he says is tantamount to a revocation of the license. And then he goes on to complain about the issue of the notice of non-compliance. Things move. I think over the page 2072, on the 20th of May, Adesh gets his notice of non-compliance. He says that's the first time he was aware of any findings. So, and then over the page again, 2073, very much around the same time as in the case of Prakash, the ministry finishes its report on Adesh's station and essentially recommends that he shouldn't be allowed to conduct any further retail marketing actions, and indeed that the whole station be decommissioned. My lords, can I just ask you to note one extra point in this part of the chronology? This ministry or officials at this point specifically took the point that Adesh was not even a licensee, because it said he didn't have an agreement with National Petroleum, and anyway, he didn't have a proper license. At that point, it seems the ministry is taking what you might call the license point against Adesh rather earlier than it took it against. The permanent secretary, sorry, on the 18th, over the page, 2074, the first affidavit in opposition to Adesh's application was made by Mr. Ramsey. He was in charge of the ministry's investigation, and that exhibits the report. So at that point, the report is made known to Adesh, the investigation known to him, and then this is another date which I'm afraid isn't in the chronology, but should. On the 26th of November, the ministry writes to Adesh in similar terms to the way it wrote to Prakash, saying, here's our report, make whatever submissions you want to. And the reference for that is at bundle 4, page 1576.
Sorry, could you repeat the number, please?
Yes, bundle 4, 1576.
Thank you.
And then, like Prakash, Adesh also put in a reply, which I'm afraid is not referred to in this chronology, on the 27th of December 2013, disputing the effect of the investigation report, and also saying, I am a licensee, and that is at bundle 4, page 1554 on. My lord, yes.
Yes, I see you have an entry at 27th December, Adesh affidavit in reply. Is this a different document?
My lord, I have a feeling that is interesting. 27th of December 2013.
Yes.
Forgive me, my lord. Yes.
Is it the same thing?
Yes, I'm not. Yes, it is, my lord. Forgive me. I hadn't spotted it was there anyway. So.
Thank you.
So anyway, Adesh basically disputes the allegations that are made against him. He too does not formally reply to the minister in answer to the letter saying, here's the report. He simply puts in his evidence. We say the same point applies to him as applies to Prakash on the, as I said, on the 16th of May 2014, the minister takes the point that Adesh doesn't even have. I think I've given you that reference. I'll give it again, volume 5, page 1645. So that's all I wanted to do by way of going through the chronology. My lords, can I just go to the arguments that were actually before the judge and the issue before the judge, because it's important to see what the arguments were in the written arguments before one goes to what the judge said was common ground. And if one goes to volume 5, just dealing first with Prakash's submissions, they're not very long. They begin at page, I think, 1582. And the basic point they take is that in paragraph 3, the enforced suspension was unlawful, and they take the point that there was no power to revoke or suspend. And likewise, page 1587 to 1588, the argument's fleshed out. From that point onwards, the point is also taken there's been unfairness in the way the suspension or revocation has been effected. That's from paragraph 26 onwards. Unfairness and unreasonableness and so on. As far as Adesh is concerned, his submissions begin at 1595, and they are to very similar effect. Paragraph 5, 1595, is in pretty well identical terms to Prakash's. Paragraph 3. And then I think 1601, paragraph 27. Very similar terms. Basically, no power to suspend or to remove. And then the other points taken about unfairness and from about 1602. Now, my lord, you'll note there is no attempt in these submissions to say that Prakash and Adesh's version of events, of what actually happened, whether the suspicions were justified, they're simply not gone into. It deals with it, if I can put it this way, at a fairly high level of generality. They're just looking at the technical legal points about whether or not there was a license, whether it was a power to suspend, and whether it was revoked. The minister's submissions begin at page 1609 in relation to Prakash, and at page 16 is his big point, if I can put it. At page 1616, 1617 in relation to Prakash, is that Prakash just didn't have a license. You can see paragraph 21, paragraph 21, 22. And he raises various other points to the effect that, anyway, the license could be terminated without war. Likewise, in relation to Adesh, his arguments in relation to Adesh are essentially founded on the lack of a license at 1645. Paragraph 45. 47. Now, I should say that in both cases, the minister also argued that even if there was a license, there was a power to suspend by virtue of the Interpretation Act. So he runs that argument too. And he also disputes the allegations of procedural unfairness. That is to say, the allegations that the intervention was made without prior notice, and also had gone on for far too long. What he doesn't do, my lords, and it is important to note, he does not say, if there was a revocation, then I was entitled to revoke. And he doesn't seek to prove in his submissions that there were actually breaches of the license. He certainly says he had grounds for supposing there was a breach, but he doesn't go on to say, and what is more, I invite the court to find there were breaches of terms. There are some brief submissions in reply, which begin at 1657 in relation to Prakash. And essentially, this reply document, as is Adesh's, which begins at 1669, all this document does is to dispute, all these documents do, is to dispute the allegation that there was no license. That's their main purpose. They say, well, there was a license, or there should be taken to be a license because I paid for one. And that's that. So that was the nature of the dispute. Now, it's perhaps understandable that when, therefore, the matter came before the judge, that the parties were more or less in agreement as to how the matter should be dealt with. And that you can see in volume 5, at page 1722. First of all, there are two passages where you pick it up. 1722, paragraph 23. Where the judge says, at the date of trial, parties agreed that there were no factual issues and that the issues for determination were purely legal ones. And also, having piled my way through the record over the last couple of days, all I can say is I'm not surprised they agree with that. There are so many factual issues. You may as well agree there are no factual issues. But anyway, one can understand why an entirely understandable course was taken to decide what you might call the points of law, which had actually arisen as a result of the submissions being made, rather than inviting the judge to find whether or not there had been, let us say, a deliberate siphoning off of bad liquid into the petrol pumps and so forth. So that is the nature of the agreement. Insofar as there are issues of fact rising out of the allegations, denials and cross-allegations, I shall ignore them for the purpose of this decision. And then the judge then goes on to say what very simply the claimant's case is at paragraph 24. And that's the basis on which she decides the claims. That's the claimant's case. That's what I've got to do. Claimant's case is that the closure of the stations amounts to revocation of licenses, and the decisions to shut down were procedurally improper and safe, and unreasonable. And that is premised on an assumption they're both holders of a license, at least a legitimate expectation. And then again, paragraph 62, page 1740, the judge also gives makes a further point, similar effect, about the nature of the agreement between the parties, page 1740. This court, sorry, my lord, yes.
I was just going to ask Mr. Knox, are you content with what is said in the second half of paragraph 3 of the respondent's case about the assumptions which need to be made? It's on page 2125.
My lord, yes, I was anticipating that question. My lord, I submit that's not, it's not the necessary implication of this. I submit that the proper way of looking at this is that the question for the court is that quite simply, no matter whose allegations are correct, was there in fact a power to suspend? And my lords, what the judge does not say that she doesn't even make a finding, for instance, that the respondent's suspicions were well-founded or indeed reasonable. And I do submit that you cannot proceed on the assumption that respondent's suspicions were reasonable. The only assumption is that the respondent had made these allegations, which the judge didn't have in any way, my lord, to decide, even as to their reasonableness. So if I can put it this way, it's a bare question of law. But we don't accept the way my learned friend characterizes the question, which results from the agreement. And we say that in particular because of the way the judge puts the matter at page 1740 in paragraph 62. And my lords, if I can just ask you to read that paragraph to yourself, that perhaps puts it better than I can, as to what the nature of the agreement and consequences of the agreement were. My lords, that deals with the background. If I can come now to my submissions, which I hope I can complete well before 1 o'clock. First submission is, was there a power to suspend vested in the minister? And I say no, for the reasons you'll have understood from our case. But my lords, if I can just deal with it briefly without going to the various judgments for the moment, just dealing with our bullet points. The first point we make is that the paper licenses did not contain a power to suspend. And if I can just ask you for the moment to look at Prakash's paper license, or what you might call old paper license, which is in bundle 1 page 120. My lords, you'll see at the beginning, I'll come to section 9 of the Petroleum Act, but the mark is quote, a marketing license, which is what these types of licenses are called by virtue of the regulations under the Petroleum Act. You can see this relates to Prakash's premises, Fyzabad, and you'll see there are just 6 conditions that I hereby grant a license to Prakash to engage in retail marketing transactions, petroleum products, subject to the conditions set out thereafter. And then there are 9 conditions, one of which, my lords, you'll note is paragraph 9, clause 9, that the license will come to an end if the agreement with National Petroleum is brought to an end. My lords, the phrase "the marketing licensee" there is clearly a reference to National Petroleum. They're referred to in quite a few other documents as the marketing licensee, because they are the wholesaler who supplies. So that's the way the license can come to an end. And all the other conditions, well, we say there are conditions, but we say there is plainly no power, express power, to suspend in the license itself. As far as Adesh is concerned, the last paper license we have for him was in fact granted to his father, which was in the same terms. And I can just give you the reference. It's at volume 4, 1286. And that, I think, was sometime. I think that was in 2006, June 2006, there and about. But it's the same term. So we first of all say we start with the paper license. Next step in our argument is that we say all the subsequent licenses granted, and there's no doubt now, as I understand it from my friend, that there were subsequent licenses. All those licenses were, quote, renewals. They were on the same terms. My lords, all we have for these, quote, renewals from the date the paper licenses stop are the various slips. Can I just give you an example of one which applies to both parties? And that's at volume 1, page 111. Well, perhaps I can just take it from 114. You can see this is just a receipt, essentially, issued to Prakash. I think at the top of the page, you'll see someone has just noted 2010. So this is presumably paid on 30th of April 2010, for the year 2011. Then likewise, the page 113, going backwards in number, but forward in time. 2011 is page 113. And then 112 is a license for 2012, and 111, the license for 2013. My lords, you'll note, just taking 112 and 111 at the moment, 112, there is a, the amount of storage is meant to be 1 million imperial gallons, and then you have to pay 100, I think it's actually $1,000 fee for that. And then in the following year, 111, he's paying $2,000 because he's going to be storing rather more. But on the face of it, my lord, all that we have is simply paid and a renewal of the license. And we say, therefore, the obvious inference is it's on the same terms. We cannot spell out of these, what you might call renewals, paperless renewals, a different term, suspension. And my lords, we say in particular, it's not just these paper renewals, but if you go back to Prakash's license at page 120. One of the things to which the licensee was entitled, paragraph 6, is this license expires on the 1st of May 2010, but may be renewed. I emphasize the word renewed for successive periods of 1 year. So I say that the proper inference is that upon every renewal, unless a new term was agreed, then the old terms continue to. Likewise, my lord, if I can just go to regulation 15 of the petroleum regulations, which in the authorities. At page 2440, 2440, regulations begin at 2436. Relevant regulation is at 2440. Relevant regulations 15 and 16. 15.2, in the case of marketing licenses granted in respect of wholesale transactions, the original period shall be 10 years in the case of peddling and retail. And retail transactions 1 year, there's a missing comma. And in the case of bunkering, 10 years. The licenses shall be renewed for successive periods, each of 10 years, 1 year. That's, I submit again, supports the renewal market. Then clause 16, regulation 16, page 2440. For the purpose of regulation 15, all renewals therein provided for shall, notwithstanding regulation 71, be upon such terms and conditions as may be agreed at the time of renewal. So we say, obviously, well, if no different terms and conditions are agreed, then they continue. It continues on the same as before. Now, my lords, we say, therefore, the license itself contains no power. Yes.
What is the legal basis? I'm not challenging the suggestion that that there weren't deemed licenses, but what is the legal basis for there to be a deemed license? Is it that the minister has taken the money and must be treated as having renewed the license as a matter of a form of estoppel?
Yes, my lords, I think I'm bound to accept that is he. But on the other hand, my lords, it's.
Could I just pursue one more point in that
Yes.
regard? If it's a form of estoppel, can one have any expectation that the minister, in agreeing under Regulation 16 the terms and conditions for the renewal, would act beyond his powers? I mean, in this regard, it does appear that he was under a statutory duty to have a power of revocation in his license and didn't have it. I mean, can one imply, or can one infer that the license didn't have that statutory requirement, namely an entitlement to revoke?
My lords, if his power, if in the exercise of his power, he had, as a matter of law, to impose, let's say, a provision for revocation, then in my submission, I accept one has to read into the licenses a power of revocation. Because otherwise, he would have acted unlawfully in granting the license.
Yeah, but that'll depend on your construction of the relevant section of the Act itself, which no doubt you'll be coming. Thank you.
I'll be coming to. My lords, it's not my principal point, but my lord, yes, my lord Briggs.
Just before we leave page 120, the paper license.
Yes.
And on the assumption that your case is, as I think it is, that once they stopped issuing paper, licensees were effectively holding over from year to year on the terms of the paper license.
Yes.
Clause 9, on the face of it, appears to be a form of automatic termination provision because of the termination of an agreement between the licensee and a third party. the taking effect of which has to be notified by the licensee who would know about it to the minister who might not know about it.
Yes.
And it doesn't look, as it stands, as a very comprehensive termination provision, not least because it doesn't appear to give the minister any right of termination at all.
No, I agree.
But if the word conditions is to mean something in a license which appears to be otherwise non-terminable at all by the minister, is a possible interpretation that the license is indeed terminable for breach of condition, because for the simple reason that these are described as conditions rather than just terms.
My lord, I wouldn't accept that. I take your lordship's point. It's a matter of contract law. One might say there is a distinction between a condition and a warrant. I would respectfully submit it's not sufficiently clear that a breach, let's say, of any of these terms would automatically carry with it the sanction of termination. Take, for instance, let us say, paragraph 1, the trading product shall be stored only at the places coloured red on the approved plan. What if in fact, entirely innocently, they were stored at somewhere a yard away from? My submission, it would be a harsh construction to say that would authorize the minister to terminate the license. So, my lords, I would not accept that automatically the use of the word conditions implies a power to terminate for breach of any of these clauses. My lord, can I just, if I may, answer that by reference to another point? If one looks at the Act, it may be that one doesn't really need to read that, to go so far. I'm looking at tab 18, I think, of the authorities. And in tab 18, at page 2429, you have section 17, 1 and 2. The important is section 17.2. Cases in which revocation of a license are to be provided for therein, in accordance with subsection 1, may, in cases, and then subsection C, there is a breach of other terms and conditions contained in a license, in a material particular, the minister being sole judge of such matter. And my lords, I submit the statutory background appears to envisage that if there is a power, then the way it works for breach, and the way this system works is that a breach has to be proved, but then it's a matter for the minister to decide whether it's material or not. And I submit that if one's going to read, in reading these licenses, if there is a power to revoke, then I submit you should read, as it were, you should interpret the license in the light of section 17.2c. My lords, it may come to much the same thing as the point your lordship is putting to. But my lords, I would hesitate to say that the use of the word conditions of itself automatically converts a breach of any term to one which the minister can automatically terminate. My lords, it will of course be my submission that, and 'tis my main submission, that even if there is a power of revocation, that doesn't matter at all for the purpose of this argument. But I agree, it's one of the points which we raise in our case, and it's not, if I can put it this way, it's not the point which I most want to focus on, because I can see the difficulty in saying that there's no power of revocation, and at the same time the minister was acting entirely within his power in granting such a license. One can see the difference. My lord, just going back to the suspension question, the first point we make is on the law. I think I've dealt with license. First point we make on the law is section 17.6 in volume, in the authorities fund, tab 17, 18, section 17.6. We say this is a classic example of a statute conferring a particular power on a particular person. And in this case, it's a power of suspension. Page 2430. And we say, well, if that's the case, the power of suspension is vested in the minister. And there's no basis whatsoever for implying into the license, or indeed into the statute, some provision that the minister has a parallel power to terminate or revoke, or sorry, to suspend. And in particular, we say that because the way subsection 6 is phrased, I can just read the first part of it. In the case of serious and repeated violations of any of the terms and conditions or of any law directions, the president may order temporary discontinuance. So the power of suspension is vested only in the president and only in certain circumstances. What my learned friend is essentially contending for is, well, even though that's there for the president, nonetheless the minister's got a much more wide-ranging power to suspend. And I say that's just inconsistent with the existence of a specific power and limited power for the president. So that's the first point we make on the suspension. So it's up to the president to suspend. Yes.
You're treating section 17.6 as a lex specialis in effect.
Yes.
Yes. But would it also colour any interpretation on 17.2c about the breach of other terms and conditions and their materiality? Because if only the president can suspend for serious and repeated violations, then the suggestion that any breach of the terms and conditions can result in the even more radical revocation would seem incongruous.
Well, of course, I would accept that, but I would also have to accept that if there is a specific power of revocation in a license which says I can revoke if, then my lords, that's that. I would accept that. But one of the difficulties here with the revocation order is in what circumstances can there be a revocation? But just for the moment, we would certainly say the minister, when exercising his powers under 17.2c, he couldn't exercise. He would have to exercise it within for proper purposes and not in an irrational way and so forth. But my lord, the premise of section 17.2c is that there is actually an express power in the license. This is the problem in the case. One could, for instance, my lord, what I would say would be perfectly lawful would have been, imagine the license you have at volume 1, page 120. Imagine it had said at the end, you had a clause 10, which said, in the event of a breach of clauses 1 and 2, the minister can terminate, but not otherwise. That would have been a perfectly lawful provision. The difficulty we have in this case is you have, as it were, two possible extremes. One extreme is just there's no power of revocation. The other extreme, on the face of it, is that there's a power of revocation for absolutely anything. Now, my submission would be that there are two submissions I make on this power of revocation. The first is, if it's to be exercised, in any event, there must be proof of breach. I'm anticipating it, but there must be proof of breach. And the reason I say that is, if you look at 17.2c, there is to be, you can provide for revocation of a license in which, and then there is breach. There's got to be a breach, in other words, to justify revocation. It's not the minister thinks there's a breach. There's got to be a breach, and then it's up to the minister to decide whether it's material. But he's got to prove the breach. But my lords, the question arises, I'm now moving, I have to admit, from the suspension, the revocation point. The question arises, what was, supposing, for instance, there was a deemed power of revocation of the license, what did it apply? And my lords, it may be that one would say that it could only be exercised by the minister where it would be not unreasonable for him to exercise. That might be the limit to speak on his power. But my lords, our primary position is we don't even get into that, because there was no attempt in this case, as I mentioned earlier, to justify the minister's actions on the basis that this was a case for revocation, as opposed to a case for suspension. My lord, if I've jumped ahead a bit, so if I may just go back to the suspension point for a moment. The reliance was placed in the Court of Appeal on the Interpretation Act. And my lords, you'll have seen our arguments on that. If I can just take it as the Interpretation Act, I think is at tab 16. We say that section, tab 16, page 2407. Section 2.1, fairly standard form, every provision of this Act extends and applies to every written law passed or made before or after the commencement of this Act, unless a contrary intention appears in this Act, importantly, or the written law. We say, well, the section 17.6, the lex specialis, it evinces a contrary intention. And then section 3, nothing in this Act shall be construed as excluding the application to a written law of a rule of construction applicable thereto and not inconsistent with this Act. And my lord, again, we take the same. It's a rule of construction that if a special provision has been made, then that ousts the need for general. And that's section 17.6. My lords, staying in this bundle, page 2408, we also say that there is no, section 45, which the Court of Appeal relied, does not give what we have called some sort of superpower to suspend, even if it's not in the license. And we submit the Court of Appeal misconstrued section 45.3. One has to start, well, I suppose one starts with section 45.1, which deals with making of statutory instruments, which not surprisingly confers a power to rescind. But 45.2 is the really important. Where a written law empowers any person or authority to do any act or thing, all such powers shall be deemed to be also given as are reasonably necessary to enable that person or authority to do that act or thing. So it is focusing on the act or thing that the power you have is to do. And so the question, it's not saying, in my submission, it's focusing on what you might call the time at which you exercise the power. And then subsection 3, I submit, is to similar effect, which is simply filling out subsection 2. Because it starts without prejudice to the generality of subsection 2, so it's going no further. Where a written law confers power, and then A is simply dealing with prohibiting or controlling or regulating matters by the licensing of it, you can impose fees. Again, that is relating to what you can do before you grant the license. I'm just looking at 3, if I can ask you, my lords, just to look at 3A. For the moment. And then 3B, and this is the important section, where a written law confers power to grant a license, state lease, permit, authority, approval or exemption. Such power shall include power to refuse to make such grant. Well, that's obviously necessary. If you've got a power, you must read in the ability not to exercise that power. And then next, power to impose reasonable conditions subject to which such grant is made. Again, we say that is dealing with the position before you make your grant of license, state license. And then the next words, which are the crucial words, and power to suspend or cancel such grant. And then, importantly, the tail end. And but nothing in this paragraph shall affect any right conferred by law on any person to appeal against any decision with respect to such grant. What I submit the tail is focusing on is the grant. It's saying, and so I submit that all of B is talking about the terms in which a grant can be made. That is to say, the relevant authority can impose conditions, and he can also impose power to suspend in the license itself. And that is I submit that's the natural reading from 2 points. First of all, this is simply filling out subsection 2. It's saying what powers you have in order to be able to do something. And in order to be able to make a lease or license, you obviously need to have the power to say in the license, I'm going to suspend. But the other point is the tail end of B. Nothing in this paragraph shall confer a right to appeal against any decision with respect to such grant. It's conferred, it's limited, in other words, to a right of appeal against terms imposed in a grant. Now, it would be rather, why not, I ask rhetorically, why doesn't it say with respect to such grant or suspension? It doesn't say that. And it doesn't say or suspension at the end, because of course, it's not dealing with power as such to suspend if that hasn't been contained in the grant of the license itself. My lords, I accept it's not, this is not a tidy piece of drafting, I accept that. But bearing in mind the 2 points I've mentioned, namely, it's all part of subsection 2, and also the tail end, I submit there's only one proper construction. And there's a further point, a rather bigger point. If my learned friend is right, this gives, on the face of it, executive bodies a remarkably wide power to suspend whenever they feel like it, no matter what happens to be in the license. And one asks, how is that supposed? So we say the Court of Appeal was wrong in its interpretation of the interpretation, even if one gets to section 45.2.
Okay.
My lord, yes.
What do you say about section 45.3c? Because that doesn't seem to be limited to what happens at the point of any particular grant, but seems to be a more roving power to withdraw an approval once given.
Yes, but my lord, I accept that. I think all I can say is that that is sufficiently clear on its own terms, that that is what it's doing, whereas 45.3 is not. Sorry, 45.3b is not.
But why shouldn't we read 45.3b, which seems to have the wide wording power to suspend or cancel such grant in the same way?
Well, my lord, I think simply for the reasons I've given. I think the main point is because the words at the tail end don't include a right of appeal against a suspension.
And can I just ask,
yes.
in what circumstances a right of appeal arises? I mean, in general law, there isn't a right of appeal against refusal of a grant of a license. You would use judicial review. So this seems to be looking to special categories of case where a particular right of appeal has been granted. Can you help us with where they lie?
My lord, no, I'm not in a position to say quite what the draftsman had in mind when he was talking about the words at the tail end. But my lords, one would expect that what might be envisaged is, let's say, take the Petroleum Act itself. If, let us say, the minister, on a renewal of a license, said to the licensee, look, I'm afraid from now on, I'm going to insist that you sell no more than, let's say, 500,000 gallons this year, and that's it. Otherwise, I'm not giving you a license. Then he's undoubtedly given you a license, but he's imposed conditions subject to which the license is being granted. And you would then what I submit could be the case, wouldn't necessarily be a right of appeal, but it'd be a right to challenge that decision by way of judicial review.
Yes, thank you very much.
But I'm not aware of any specific statutes which, as we're in terms, give a right of appeal against a decision, a right of appeal as opposed to judicial review. My Lord, yes. Yes.
Is another possible interpretation of the tail piece of B, that's 3B, that the phrase any decision with respect to such a grant or to such grant could include a decision to suspend or cancel it?
Well, in my submission, no, because then it would say with respect to such grant or suspension.
Right.
Well, because, my lords, that would be a more natural way of reading it. Well, no doubt you would say that's because that's the way I want to read it. But I submit that the clearer, can I start with this proposition? The clearest way of expressing that concept would have indeed been to add words, or suspension, or cancellation. And it doesn't. My Lord, I revert to my initial point in subsection 2, that this is all filling out the what you might call the initial powers, rather than any powers on top. My Lord, can I just say an answer to my to Lord Sales's point in relation to 3C? Of course, that is 3B is dealing with formal matters, licenses, state leases, and so forth. Permits, authorities. These, in my submission, would tend to be, not necessarily, but would tend to be more formal documents and arrangements which would go on for a considerable period of time. A mere approval of a person or thing, my lords, I'm not quite sure what exactly that would cover, but it wouldn't, on the whole, one I would guess, is something which would have necessarily terms attached to it, or be for a particular or long period of time. I also would like to reiterate the point I made a moment ago in relation to B, and that is, can it really have been the intention of this interpretation to confer a wide power on the minister, effectively to override the terms of his own express terms of his license? He says nothing. My Lord, yes.
Yes, sorry, Mr. Knox. First of all, in relation to subparagraph C, I mean,
Yes.
there are many regulatory regimes where someone is required to be a fit and proper person to conduct various activities. And
Yes.
I would have thought that C is directed naturally to that sort of case. But that seems to me to be a point against you, because that also is a formal decision where someone needs to be a fit and proper person to carry on an activity. So again, the distinction that you're urging upon us between B and C seems, speaking for myself, to be a strained one. Well, but the second thing I wanted to say is I do follow your argument. I think we need to remember that what we're looking at in section 45 is a general interpretation act. That's looking at every power on the statute book, subject to contrary indication. And I'm understanding, in a sense, your primary point to be that the regime in section 17 is a special regime where it is required that specific indications be given in the license itself of when it can be revoked, and that doesn't stand, or at any rate stand very neatly with a background wide-ranging power, which is that conferred in ordinary cases by section 45. Have I understood that correct?
My lords, that is my primary argument. I think, my lord, as you put it in a way which, well, better than I have, I think I'll leave it at that for the moment. But you have my point on section 45(3)(e) as well.
Yes, thank
so
you.
My lord, can I just mention one other point on this matter, what you might call implied power to suspend? My learned friend has relied on a case which I think is in tab 5 of the authorities bundle. That is the case of Queen Leicester Gaming Club v. the Gambling Commission, paragraph 14. I just want to deal with this point briefly, if I may. I think I've got enough time before lunch to do so.
What page, please?
2206.
Thank you.
My learned friend draws attention to paragraph 14 in this, and the principle that the statutory body has effectively all powers to do things which are regarded as incidental to the relevant express power, and reference is made to the Great Eastern Railway case in the 1880s. My lords, this principle, which my learned friend is relying on, is an entirely, not different principle, but not the same principle. This principle is the principle about capacity. In other words, if the question whether or not something is, for the sake of example, within a local authority's capacity, you look not only at the express powers, but whatever is necessarily incidental to the exercise of the power. That is a very different thing from here, where what my learned friend is seeking to do is to imply a term into a contractual document. And I submit this authority is of no assistance, or this principle is of no assistance in deciding whether or not there's an implied term in the contract. It deals solely with the question of capacity and to what extent does the public body or statutory body have. My lords, I don't propose to go to the particular sections, but we refer in our case to the Fire Service Act and also to the Environmental Authority Act, which give the fire service or the chief of the fire service the power to go to court and to get an order if he thinks there's a risk or hazard of fire. And the relevant section, I don't think this is like here, but the Act itself is at, I think I'm right in saying 2393. And the relevant page is 2398, section 45.3. So there's a specific power that the fire service have in relation to any public premises when there's a danger of damage to the public. 45.3 for the right to ask for an ex parte injunction. And then the Environmental Management Act, tab 14, page 2388. There's a power on the Environmental Authority to whatever steps are appropriate, undertake such emergency response activities as required to protect human health in certain settings. So this is not a case where there is no other way of dealing with the problem. And finally, my lord, just on the suspension point, it's a point we make, forgive me, my lord, Lord Ham.
You, in the same paragraph, you acknowledge that you could apply for an interim injunction.
Yes.
In what circumstances do you accept that could be done, and what exactly would be the legal basis for that injunction?
Well, on the basis that there was a breach or anticipated breach of the terms of the license, which would cause considerable damage, which would require shutting the premises down. On the basis that the dangerous activity was a breach of the terms of the license. So you would say, these are the terms of the license. There has been, or there will be, or there's about to be a breach of the terms of the license. It's jolly dangerous. Please make an order restraining the defendants from carrying on their petroleum activities until they have remedied the problem. My lord, I do submit it would be possible to get in. Just the chief fire officer, I think. Yeah. And the advantage and the important point of that is everything would be subject to the court's control. Rather than what we've got in this case is a disastrous position where the investigation just trundles on for at least a year, and then it's another year and a half till the matter gets to court. And then you have court proceedings without any control by the court of the time which the investigation is taking. And we say that's the vice, really, of this alleged power of suspension. But I accept, my lord, that the minister would have to show that there would be an anticipated or likely breach of the terms of the license, such as would cause danger to the public, and would be a breach of the terms. Therefore, I can stop this activity for the time being. My lord, that's all I have to say on suspension. As far as revocation is concerned, the important points is that if I can just draw your attention to the judge's finding on the question, or findings on the question of revocation. First of all, volume 5, paragraph 1731. Paragraphs 42 to 43. The judge finds the decisions have been described as suspensions or revocations, while the initial position, such as was to be gleaned from the earlier affidavit of Mr. Ramsey, appeared to be that the measure was temporary. Up to the time this matter came on for trial, there had been no clear indication that the PM, Prakash Maharaj, would be given an opportunity to re-enter and resume operations. It has not helped that I was unable to get from senior counsel for the defendants a direct answer as to how he, Prakash Maharaj, could address the notice of non-compliance, and specifically senior counsel's instructions as to when, if at all, he would be allowed to resume operations. I am forced to conclude that, especially since he was served with the non-compliance notice while his deprivation of access continued, that in effect the MEEE has purported to fully revoke his license. And then she continues in relation to Prakash at page, well, in relation to Adesh, she continues at paragraph 44 and 45. And effectively, she says the ministry's position in relation to Adesh, that he didn't have a license at all, came to the same thing. That's paragraph 45. Final sentence of 45. I think it can safely be said that this suspension, inverted commas, was not intended to be temporary, and shortly after 1st December 2012, the ministry took a decision to shut down Adesh's station permanently. And then paragraph 67 on page 1742. The final sentence in particular. Since the licenses do not provide for it, I accept the submission of counsel for the claimants that the decision of the ministry to revoke the claimants' licenses and to effectively shut down their businesses are illegal, null and void. So again, the judge has found there was a revocation, and in my submission, she was plainly correct so to find, and indeed it was within, if I may put it this way, it was within her what you might call remit to make that finding. It cannot be said that that was an irrational finding that wasn't open to her as the first instance judge. And the reason, I just give very brief reasons. First, the prolonged closure of the station, beyond the expiry dates of the actual licenses, which were, as I've said, December 2013 and May 2014, or at least May 2013, doesn't matter. The prolonged closure can only be explained as a revocation. Second, even if that's not right, the stance of the minister at the hearing, when his written submission on the 17th of May 2014, in saying that there simply was no license, and not being able to say when, if at all, Prakash could get back into the premises, in my submission, what has effectively happened here is there's been a revocation. And I submit that's a revocation within the meaning of the Act for the purpose of damages, because it is important on the question. Now, my lords, I've made this point already. My basic point of revocation revocation is this. The power to revoke, the one I've made already, the power to revoke requires proof of breach for the reasons I mentioned in relation to section 17. Word is. But the minister did not seek to justify on the basis of a proven breach, nor did he, indeed, he disavowed any such thing when he agreed that this was not an issue in the case. So I submit there was here a wrongful revocation and the judge was entitled to set a fine. My lord, that makes the debate which I got drawn into a little earlier in relation to, forgive me, my Lord Handel.
If there was a revocation, when exactly was it?
Well, my lord, you'll see how the judge put it. He effectively from the my lord, I accept. I was wondering about this. When exactly? Well, if one had to pick a point in time, what was that? My lord, my answer is. I know this is a slightly evasive answer. It doesn't matter precisely when revocation took place, because it had certainly taken place by the time of the judgment. It may be difficult to identify. Perhaps the most obvious point would be to say, at the moment the minister says, you haven't even got a license. At that point, the minister's position is clear. He is not saying, I might let you back in, which is the whole premise of the suspension. He's basically saying, you haven't got a license anyway, so why should I let you? So, my lord, that's my best effort. My Lord Briggs.
I may have got the chronology wrong, but had not the two licenses in any event expired by a fluxion of time by the time that the judge came to deal with the matter at the trial?
Forgive me, my lord, yes, that is right.
So one interpretation of the minister saying, well, there wasn't a license, there's no basis for being put back in, is that they were annual licenses and they hadn't been renewed.
Yes, I accept that. Yes.
A point which is, I think, taken against you by the respondents in their written case.
Yes, yes. Well, my lords, the curious thing is everyone was obviously, it's not, as I understand it, a point the minister actually took in front of the judge. He didn't say, oh, but what are we all fussing about? His licenses came to an end last month or last year. My lord, one can understand why, because of course, in real life, these are rolling licenses. They continue from year to year. Although I do accept there was no specific application to renew beyond at least May 2014. But my lord, going back to the question, when did the revocation take effect? I suppose I've given my first answer. My second answer would be, as at the point at which the licenses came to an end, at least at that point. But then my lords, my initial position is that I don't have to show precisely when there was a revocation to prove an unlawful action. I just have to show that the effect of the initial closure, followed by the continued time through which this investigation took place, without any opportunity to get back in, I submit that is sufficient to amount to a revocation in any event. And my lord, the judge, the way the judge put it is that she inferred that actually that was always the intention anyway. So that's the other way of, as we're putting a point in time for revocation. My lords, as far as the question of the point which was discussed earlier about was there a power of revocation in terms of the license, my lord, my primary position is it just doesn't matter. My alternative position is if it does for some reason matter, then it's at section 17 of the Act. Proper construction, in my submission, all this required, at page 24, 28, 29. 24, 29, section 17, a license shall contain appropriate sanctions, including the revocation license in case of failure. In my submission, the operative word is sanctions. In other words, there has to be some sanction. But as long as there's a sanction, there doesn't have to be a revocation of the license imposed as well. And in other words, the words including the revocation of the license are permissive. And the reason I say that is section 17.2 is undoubtedly permissive. Cases in which revocation of a license are to be provided for therein may include cases. And that obviously is, as it were, is undoubtedly saying you don't have to make every single term or condition something which attracts a revocation. So there has to, my lord.
Mr. Knox, I can see your point that a license would be compliant with section 17.1 if it contains some sanctions, perhaps other than revocation. But if you go back to page 120, I can't see that there's any express sanction unless something is implied so as to make it compliant with the Act. Then it's hard to see how that would exclude revocation.
My lord, I think the best I can do, my lord, yes, I think the best I can do on that is section 9, clause 9, which is the power to give me.
Yes. Sorry, Mr. Knox. I was wondering about, when you say section 9, do you mean clause 9 of the license?
Yes, clause 9 of the license, yes.
Yes, I was wondering about that because presumably in the agreement between NP as the marketing licensee and the garage, NP will have all sorts of terms as to maintaining proper standards by the garage. So I was wondering whether, in fact, the practical effect of clause 9 was that the minister thought that there was going to be intensive scrutiny of what was going on at the garage by NP, and that was going to be a sufficient sanction, including, if need be, revocation, because MP can bring things to an end, to give sufficient satisfaction that the garage is going to be maintaining proper standards sufficient to allow the license to continue.
Well, my lord, that indeed was, you've anticipated my submission, because if you go to page 100, volume 1, page 153, you will see the right to terminate, which is vested in NP. This is Prakash's NP license. And it begins at page 123. But the relevant parts are 153 onwards, which give NP the right to terminate. And you'll see quite a few rights to terminate, which is back to clause 7. And indeed, it continues to page 155.
Yes, thank you very much.
So, my lord, that would be an answer to my Lord Briggs's point. I submit that would be a sanction. Sufficient to, as well, make the license lawful, even without an express power of revocation. But my lords, as I said, my main point is I don't need to get into that because no one, it's not been said there was a power to revoke. Sorry, there was no attempt to justify what happened on the basis of the minister actually being able to revoke in this case. My lords, I think that leaves me with the question of damages as my next main head. Yes. There's no doubt damages were claimed in the judicial review claim. The judge did at one point ask before the hearing was considering the question of alternative remedies, and she did invite submissions on whether the arbitration route was the right way of going, Section 18. And one can see that in the chronology. She was persuaded that it was perfectly proper to go by the way of judicial review. And you can see that, my lords, the reference is at bundle 2, page 498, paragraph 3. May not matter very much, but that undoubtedly was one of the background matters case. So she decides that it's perfectly all right by way of judicial review. And in my submission, there plainly was. It's worth noting. Prakash said he was losing 20,000 Trinidad dollars a day. Adesh said he was losing 25,000 a day. That was in their evidence. And they did put in details of their previous 2 years, or previous year or so, of trading, in very simple terms at least. Prakash's is at page 257 of volume 1, where he puts in his figures, I think, for 2011. And you can see, if you go to page 257, going to 258, it's not a very easy to read table, but you can see on 2258, you can see the upper total. There's a split. The upper total is $5.8 million on, and the lower total, and that's sales. And the lower total is $5.185 million. So he's a difference of about $650,000. And in that year, that was 2011. So he was saying, I'm trading profit. And as far as Adesh is, he put in a similar claim at volume 4, page 1336. I'm sure he was making quite such a profit. But in any event, he gives, I think, a couple of years worth of figures at 1436. So it was a properly made claim. And I submit it's just dealing with the act itself at the moment in the authorities part. I submit that it is implicit, that, well, it is explicit. I can just make my submission. It is explicit that a claim for reparation or damages can be made by way of arbitration, where there's been a wrongful revocation. I say it's also implicit that if the minister, in a case like this, chooses not to exercise the right to go to arbitration, then there's no reason why the court shouldn't be able to deal with the matter. And one can pick it up at tab 18 in the authority, section 17, I think it's section 17.2c is the starting point, which we've looked at.
Which page, please?
2429.
Thank you.
2429, I'm just taking it, so to speak, from the beginning. This deals with the cases in which revocation can be imposed on a license, 2C, 17.2c, and then over the page, section 18, 1, 2430. Where in the case of revocation under a provision in the license made in accordance with section 2C or G, I should say 2C or G is an alleged willful misrepresentation by licensee, but no other. A licensee is aggrieved by the decision of the minister to revoke the license. He may have recourse to arbitration in accordance with this act. And then there's a provision for in subsection 2 as to whether or not the revocations take effect until the arbitration's completed. And then section 22.2 or 22.1, except with the consent of the president, the activities which are given rise to arbitration shall be discontinued until the issue of any award. If the award recognizes the complaint was justified, provision shall be made therein for any necessary reparation in favour of the claimant. So there's no doubt that reparation can be given to the claimant. And in my submission, forgive me, my lords, I've just lost the reference, but in my submission, it's quite plain that the minister, I think it's section 20, subsection 1, and subsection 2. Subsection 21 imposes a requirement for arbitration. And then subsection 20, subsection 2, where a licensee proceeds otherwise than is in this act provided, the minister or a licensee may, at any time after appearance and before delivering pleadings, apply to a judge of the High Court to stay the proceeding, and such judge shall thereupon stay them, and provision for how the arbitration is carried out. So, in my submission, the proper construction of this act is arbitration is the primary remedy if, in fact, the parties decide or willing not to go to arbitration, but to leave it to the court once the matter is being begun in the court jurisdiction. Then the court can deal with the matter. There's no reason why not. And in this case, the minister did not elect to go for arbitration. So, my lords, what I submit is this. This was a wrongful revocation. If this was pursuant to a term in the license, then it comes squarely within a revocation under section 17, subsection 2, subsection 2C. In other words, in one sense, my damages argument rather likes the notion there was a power to revoke the license. But I say, let's say for the moment, there was no power to revoke in any meaningful sense. I say, if that is what the minister has done, then on a proper construction of this act, there is still a power for the court or the arbitrator to make an award. It would be an astonishing thing if, in fact, there's no power to revoke, but the minister then revokes, that the licensee is in a worse position than one who was with a license, whose license did allow a power. So, my lords, that's what we say about the act. My lords, I notice the time, it's 4 minutes past 1. I'm happy to continue because I think I'm only going to be about 5 minutes of that. I'm happy to continue after lunch.
Could I just confirm with the technical people that the meeting can run on for another 5 minutes successfully?
That is correct, Lord Hodge.
Well, unless my colleagues feel otherwise, I think we should allow you to finish your submissions. Thank you very much.
I'm much obliged. My lords, I've dealt with damages for revocation under the Act. I accept that there doesn't appear to be any power under the Act to give damages for wrongful suspension. It doesn't seem to be there. On the other hand, we do also say, both in relation to suspension and in relation to revocation, that there's another route, so to speak, by which damages can be awarded if my clients are right. And that is under the Constitution. My lords, we deal with this in our case, but my lords, you'll be familiar, no doubt, with section, I think it's 4A, the Constitution, which we have in the bundle at, I can just give you the reference, tab 13. The relevant page is 2379. And one of the rights is recognized, if I can just read it, the right of the individual to life, liberty, security of the person, and then importantly, and enjoyment of property, and the right not to be deprived thereof except by due process. And my lord, the question arises, or has arisen in the past, is a license something that can properly be regarded as property, which is enjoyed within the meaning of section 4A? My lords, we say, yes, it most certainly can be, and we rely on that on the decision of Papanet, which is at tab 22, which is a decision of your lordship's board from Trinidad on this section, and the relevant paragraph, which related to a license for taxi drivers and the withdrawal of a license for taxi drivers. And it's at page tab 2, 2156 is where it begins. The relevant paragraphs, which discuss the European Court of Human Rights decisions as well. One of them is 23, 2164. paragraphs 23 to 24. And essentially to 26. But the board there held that I think a license to continue operating as a series of taxis, there was no reason why that shouldn't constitute property for the purpose of the. My lords, in this case, what had happened is there had been a statutory instrument which had effectively withdrawn the benefits of the license from the tenants. So, my lords, we say no reason why damages shouldn't be awarded under the Constitution, both for wrongful suspension and for wrongful revocation. When I say both, I mean it doesn't matter how you characterise the act. My lords, very brief. My lord, yes.
Mr. Knox, I also wondered whether you couldn't rely on Section 4A in relation to your ownership of the land. From my understanding, in both the case of Adesh and Prakash, they own the premises, and but for the want of a license, they'd be able to put those premises to gainful use in their businesses. I wonder whether you wanted to say anything about that.
Well, my lords, I certainly say it naturally. I think it's right that Prakash is the owner of this premises. He's actually got the freehold. As far as Adesh is concerned, the position isn't quite so clear. He appears to have been operating under a lease from National Petroleum. But one of the points taken by the ministry was National Petroleum itself didn't have any rights to it. But in any event, but my lords, I certainly take, but even if he may not have had, even if his rights may only have been the rights of a tenant under a landlord with no right to, who himself has no right to land, that doesn't matter. He still has a right to a tenant until as it were, until the matter is sorted out. But we would certainly adopt, my lord's suggestion that the effect of what has happened is not just that our business has been, the land has been taken, or the use of our land. So it's a fortiori to the taxi case, the Appellants.
Yes, thank you.
My lords, I think I've got another minute. I think that's all I'm going to take. The question is, what about the extent of the damages? As I've said, I accept that the licenses had run out by the time the hearing took place in front of the judge. But at all times up to the hearing in front of the judge, they were claiming an order of mandamus. They wanted to get back in. And I submit it's a natural consequence if there was a wrongful act by the minister. The natural consequence of that is that they didn't bother applying for what would be an entirely futile, making an entirely futile application for an extension of their licensing, when they were already making a claim for mandamus, which was continuing beyond that, which had expired. In other words, from early December from 2013 and 2014 onwards, they were still claiming an order for mandamus, the restoration of their licenses, which in real life means, obviously, it means anything. And I want a new license too. So whereas I accept that technically there was no application for new license, they certainly were pressing to be restored to their premises. And therefore, the award of damages should include such damage as they've sustained by virtue of the continued exclusion from their property. And my lords, if I may pick up my Lord Sales' point, a fortiori in relation to their exclusion from the land itself, as opposed to from the business. I submit, therefore, there's no reason why such damages could not extend beyond the expiry of their actual licensing. My lords, that really deals with my submissions. Can I just mention one other point? We do deal with the point about unfairness. That is to say that what I call the convoluted, namely, what if there was a power to suspend and there was no revocation? We do say the power to suspend was exercised unfair, essentially for the reasons which we set out in paragraph 71 onwards of our submissions at E209, for the reasons the judge gives at E1743, paragraph 68 to 73, and Mr. Justice of Appeal Jamadar gives at paragraphs 10 to 11. at 1969. And we say what is obviously wrong in this case is that we have been, quote, suspended, and then we haven't been able to get back in throughout a prolonged investigation, even by the time the matter gets to court. And I submit that it's obvious there has been unfairness in the way the suspension is being carried out, even if there was a penalty, for the reasons we set out. I don't think I would help. I'm very conscious of the time. So I think, my lords, those are answered. Yes.
Thank you very much, Mr. Knox. In your reply speech, and no doubt Mr. Rowe in his speech can tell us how you would propose we deal with the outcome of the case, whether we're for you or against you. But we can deal with that in your reply.
I'm obliged, my lord.
We'll have the short adjournment now and resume at 2 o'clock. Thank you very much.
Thank you.